My name is Jason Epstein. I'm a criminal defense attorney in Chicago, and the defense team for George in the George Floyd case, the attorneys for Derek Chauvin, recently made a filing attempting to argue that the prosecutor was improperly appointed and therefore there's no jurisdiction in the case because there wasn't an indictment. Looking at the statutes in Minnesota, I gotta give credit for making the old college try. Your defense lawyer never give up, right? Never say die. But I don't think it's going to fly. The appellate court's not going to accept these arguments that they're attempting to make. So let's get into it. So I'm an attorney in Illinois. I'm not an attorney in Minnesota, so take it for what it's worth. But they're arguing basically two things. Well, first of all, Derek Chauvin was never indicted. There was never an indictment against him. He was charged by what's called a complaint. In the United States, most states, there's two ways to be charged with a crime. One is by indictment, and the other way is by complaint or information, the same thing. Indictment is like what you see on the movies. Somebody's been indicted. Generally what you have is a jury. They assemble a jury in a courtroom with only the prosecutor and the jury, and the prosecutor presents evidence. They say, the joke is you can indict a bologna sandwich because, it's just one-sided. The jury, the grand jury, doesn't get to hear all of the facts. They hear what the prosecutor is presenting. But it's an early stage. It's to see if a crime should be charged. Now, a complaint or information is done in front of a judge. The defense can be there. The defense can have a lawyer there. They have witnesses, and the defense can cross-examine those witnesses. Same question, is this person, is there sufficient evidence to say that this individual committed a crime? In this case, Derek Chauvin was charged by complaint. So they didn't have an indictment. In Minnesota, that's not a problem though in Minnesota, because you have to be indicted if the offense is punishable by life imprisonment. He was not charged with anything where life imprisonment was at issue. He was charged with second-degree murder, third-degree murder, and second-degree manslaughter. None of those carry life imprisonment for Derek Chauvin. So they didn't have to have an indictment. Had it been murder, first-degree murder, they might have a better argument, but that's not the case here. So that would probably be their strongest argument, but they're trying to conflate that with how the Attorney General was appointed and how a prosecutor comes on the case. It generally doesn't make a lot of difference. It's a prosecutor. It doesn't matter how they get there. But, we'll talk about it. So 7.01 in Minnesota governs the appointment of a prosecutor when the county prosecutor requests that the Attorney General be in the case. If there's a request and the Attorney General accepts, that's it. And that's it. That's it, because that's really going to end this argument by and large. That all of that was met. And once all of that is met, it's kind of over for it's not really a jurisdictional issue. It's not a jurisdictional issue to say that the prosecutor was appointed improperly. Unless it was like the offense specifically said they had to have an indictment. But anyway, so that's 7.01. Under 8.01, this is their stronger argument, and that is if the governor appoints the Attorney General, and here we did, Walz appointed Ellison, that statute says it's on an indicted offense. So it specifically says an indictment. Now, why isn't that the winning argument? Because 7.01 already takes care of it. And the appellate courts generally are going to ignore arguments that kind of fall secondary. In other words, if it was done the right way one way, just because it wasn't done right the other way, it doesn't matter. It doesn't matter. Now, there's another reason, and that is more likely, is they're going to say, the appellate court's going to say you forfeited this argument. You waived it. Also, latches. Latches is when you took too long to make the argument. Now, what am I talking about? This is now at the post-conviction petition level. Trial occurred, appeal occurred, and now we're at the post-conviction level. That's like after everything's occurred. The court's going to say the trial lawyer should have made this argument. And they're going to say the appellate court, the appeal lawyer, should have made the argument that the trial court lawyer should have made the argument. So at this level, he's going to have to say both lawyers at the appeal and the trial screwed up and should have made this argument. And it gets harder and harder to make it as the further you go along. It's like two different lawyers should have made the argument. They had the opportunity. They didn't make the argument. So you basically forfeited. You waived that argument. As well, in the trial court, the trial lawyer did attempt to have the prosecutor removed for different reasons. Not the reasons argued here, but for different reasons. But the reason I mention it is because it was a live issue. Is the prosecutor properly on this case was before the court. And nobody talked about 7.1 or 8.01. So, again, the appellate court's going to say you waived that argument. But that's, again, secondary to the fact that 7.01, even if you raise it, 7.01 covers this, and it's met properly. So legally, I don't think there's a basis. Unfortunately, since this verdict, both sides are playing the race card, and this really isn't a race issue. This isn't a race case. It really has little to do with race. I mean, nothing that was presented that I know of shows Chauvin hated Floyd because he was black or vice versa. So the race card, everybody needs to stop playing the race card at every juncture. No police officer in any city, in any county, should be kneeling on somebody's neck. It's that simple. Because guess what happens? People die. People die. You kneel on somebody's neck, that is a very severe action. If you're going to be shot or killed, shoot them. Use your taser. You have handcuffs. You don't kneel on somebody's neck. I think most all jurisdictions ban this practice. The other argument is that, he died from drugs he had in the system. That's a fallacious argument. Don't make that argument. In law school, we actually have that specific question. If you pull the plug on somebody that's going to die in an hour, but you pull the life support early, did you murder him? Yes. Yes, you murdered him. You brought about his death for something that might happen. He might have died today. He might have died tomorrow. And if you take that argument to the extreme, you can kill a 5-year-old because they're going to die when they're 80. They're going to die. That's ridiculous. It's a dumb argument, and that's how dumb the argument is that George Floyd had something in the system that could have led to his death. It's speculative at best. What more likely led to his death was somebody kneeling on his neck. Crazy, right? Crazy. The drug possibility is possible. And, whether or not someone's a good person or a bad person has nothing to do with the level of victim they are. I mean, is Jack the Ripper a model citizen because he killed prostitutes? And therefore, he's a good guy? No, he's still a murderer. He murdered these women regardless whether they were doing something illegal or not. It has nothing to do with the legal analysis of did you murder somebody. So, this plain who's a good guy is ridiculous. It just don't do it. It doesn't matter. You can't kill people. In fact, in many cases, when there's a murder, it's usually between two bad guys. It's often between two bad guys. Most of the murders in this country are between gangs. And so it's gangs shooting gangs. We're just going to say, you can kill this guy because he was a gang? Actually, I think that kind of plays out, believe it or not, but that's for another video. It's improper, it's not legal, and we can't, as a civilized society, start trying to justify murders based on who was murdered. Hope that helps. Have a good day.